Honourable Mr. Speaker, honourable members of Parliament, colleague Advocate Galeka, distinguished guests, good morning everyone, including the many people who are following us in a direct transmission on TV. We are honoured to have with us today Advocate Koleka Galeka, Public Protector of South Africa, who will deliver a lecture on the theme Transparency, Fairness and Accountability Cornerstones of Good Administration. Advocate Galeka and myself are not only colleagues in office, but also co-directors of the 24-member World Board of the International Ombudsman Institute. On my part, I am one of the 5 directors that represent Europe, while on her part, Advocate Galeka is not only one of the 4 directors that represent Africa on the same World Board, but is also President of the Board of Directors for Africa, and in that capacity is one of the 8 members of the Executive Board of the IOI. The IOI was established in 1978 and is the only global organization for cooperation of more than 200 independent ombudsman institutions from more than 100 countries worldwide. The institution is organized in 6 regional chapters: Africa, Asia, Australasia and the Pacific, Europe, the Caribbean and Latin America, and North America. In its effort to focus on good governance and capacity building, the organization supports its members in a threefold manner: training, research, and regional subsidies for projects. I start my presentation with a straight question. What is the big deal? Don't we all know that transparency, fairness, and accountability are the cornerstones of good administration? With a likewise straight answer, I say, of course. However, there's a but. Because where transparent behavior, fair conduct, and accountable modi operandi are in question, there is a strong tendency towards widespread lip service. And unfortunately, lip service translates itself into a disservice. I am afraid that in the social fabric of our country, as it stands at present, many speak, but a few care. It is the mission of every ombudsman to care. Because if an ombudsman does not do so, the office is in a weaker position to promote and invoke administrative justice. There are times when, in the very interest of the institution, an ombudsman has to hold back and remain silent. There are also other times when an ombudsman has to be firm and has to make his voice heard and act consistently without fear. Every ombudsman, by whatever name or gender is defined or called, should stand up for the principles that we are addressing this morning. because it is the right thing to do in the interest of the common good, especially in the interest of those persons who vis-à-vis the state are vulnerable or are without a voice, or who do not even have the strength to whisper. I also strongly believe that the Ombudsman have an obligation to be on the front line for the promotion and observance of fundamental rights and freedoms. Whether such a mandate forms directly or indirectly part of their mandate or not. This is all more important in our country. Malta has a surface area of 95 square miles, or 246 square kilometers, islands included. The present population of these islands is just over 563,000 individuals. As at 31st December 23, the last official public statistics available, third country nationals present in Malta amounted to 112,892. 20% of the population of these islands. 67,176 came from Asia. 27,433 from European non-EU states. 8,075 from South America. 8,039 from Africa. 1,872 from North America. 250 from Oceania, and 47 unknown. Official statistics. I have omitted nationals coming from EU nation states because they do have the protection which they merit. But what about third country nationals? Do not even they have rights that deserve protection? Is the Ombudsman not for them as well? Has Malta become or will become a multiracial state in the years to come? Are we prepared fully as a civilized country to accept and demonstrate respect towards third country nationals? Of a fact, I am more than sure, third country nationals are persons who have a right to be treated lawfully with respect and dignity. Advocate Galeka will have an excellent opportunity to give us her insight on the sensitive issue of multiracial integration in modern societies. We shall all be eager to listen with care and attention to her presentation on this matter, primarily because third country nationals are persons before being service providers of necessity of this country. Let me move on. Being the opposite of good administration, bad administration is what every public service ombudsman, including the Parliamentary Ombudsman, should strive to remove from the vocabulary. An ombudsman is not there to investigate just complaints on acts or omissions of government, meaning the public service and the public administration, in the performance of their administrative functions, but is also there to help and resolve and find remedies for administrative practice that run counter to administrative justice, transparency, and accountability. By no mere coincidence, these principles are relevant not only where good administration is concerned, but also are benchmarks of the rule of law. In Malta, The Ombudsman oversees what the public service and the public administration do or fail to do. Not simply within the context of complaints investigations, but also through own initiative investigations, with no other agenda but to improve public services for the benefit of the public. The office can act as an overseer because it is independent of government at 360 degrees and enjoys constitutional protection. Advocate Galeka will surely address these matters from her viewpoint. I quote from one of former EU Ombudsman Emily O'Reilly's consistently remarkable speeches. People should know that they have the right to an open and fair public administration and have a right to redress. A public administration that is not built on these principles is not a good public administration. The public service and the public administration have an obligation to place fairness, justice, and accountability as their quality testers in their practical day-to-day operations. No ombudsman can take the risk to accept that these principles become mere buzzwords. Public service officials should never, but never, feel in any way offended when a constitutional office like the Ombudsman speaks in clear and at times critical terms on the administrative operations of public offices. As persons, even if in high offices, we are all birds of passage. And we should never, but never sit on our laurels, past and present, in order to shape our future. Public service cannot defend their methods simply by stating that what they do is according to law. Public administrators have an obligation to abide by rules and proper conduct, especially rules that are formulated by themselves and promoted by public bodies. They may not like, or they may not endorse recommendations submitted to them by ombudsmen, but nonetheless, they must do their share to cooperate with the ombudsman, which often they do, or at least where the present ombudsman is concerned. Public service should keep in mind that according to the Ombudsman Act 1995, there is maladministration when an administrative decision, recommendation, act or omission of government, by government, you know what I said, appears to have been contrary to law, or is unreasonable, unjust, oppressive, or improperly discriminatory, or was taken in accordance with a law or practice that is or may be unreasonable, unjust, oppressive, or improperly discriminatory, or is based wholly or partly on a mistake of law or fact, and the most important one of them all, that act or omission is wrong. Wrong, we're saying. Not legal or wrong. I am more than convinced that Advocate Galeka will share her experiences with us on these matters, in particular on what happened in the past in South Africa and what is the present situation where the recommendations of the public protector are not implemented by the public authorities. I'm approaching the end. Rhetoric and paper principles do not resolve problems. I shall insist on asking, maybe someday I will get a clear answer, as a matter of course rather than because of my insistent or instinct of persuasion. Should not bona fide persons have a right to see that their affairs are managed by public offices with impartiality? with fairness and within a reasonable time. Should not bona fide persons have the right to be heard before an individual measure is taken that would affect them adversely? Should not persons have the right to free access to a public file that affects them? Is it asking too much from the public administration to give reasons for its decisions? I quote again from Mrs. O'Reilly. It is precisely the task of the Ombudsman to enable an administration to do things not because it is told to do so by the Ombudsman or by the courts, but because it instinctively and unhesitatingly knows it is the right thing to do. I am confident that even on this matter, Advocate Galeka will help us all with the proper answers even on this matter. Thank you all for hearing me out.